recording. So week 7 cloud seminar, and I'll share my screen and we'll have a look at the content, the questions. So seminar week 7. Okay. All right. So the first question, it's clear the area under the ACL. And if you have a question in the exam that, of course, refers to the ACL, you only answer under Chapter 13. So this one is similar to another case. And does anyone have any ideas as to... So let's write this as the issue, because that's exactly what the issue is. So what would the rule be here? Does anyone know?
Sure, I'm behind on my homework this week. I haven't done it.
Yeah, that's all right. Can you open your textbooks to Chapter 13 if you have them? That's all right. Everyone was behind in seminars today too. I can relate.
So, Michelle, is it a person must not trade or commerce engage in conduct that is misleading or deceptive or is likely to mislead or deceive?
Yeah, is that you, Darren?
Yes, it is.
Sorry, I can, yeah, it's just really low, that's all.
Yep, sorry about that. I'll try and...
No, I've turned it up, that's all right. Yep, so it says contravene Section 18, so we know it's misleading or deceptive conduct. Very good. Does anyone know the case? Okay, so misleading or
Michelle, is it the ACCC versus TPG, the one where the marketing and advertising?
Yeah, so this one's actually not an advertising case, and I'll just explain that. And I'm sorry, next door's building a shed, so I hope it's not too noisy. They've got power tools going. There's 3 areas where there can be misleading or deceptive conduct. And the question, if there's one in the exam, for instance, it would be very clear. It's either an advertising question, so there's an advertisement, whether it's internet, TV, so on, where they've contravened Section 18. Or you can use it in pre-contractual negotiations, where, say, you're buying a house and someone represents something like fraudulent misrepresentation. Well, under Section 18, you can prosecute. The other area is as a weapon for business. Yes, Parkdale and Puxu, very good, Darren. So often companies will take other companies to court to say you've ripped off our product, or you're using our name, or you're using our brand, and consumers will get confused because they may think that it is our company or that you are associated with our company. And I'm not going to go too deep into Australian consumer law, but there's a lot more rules here. But if a company was to register their design or their product, then realistically you can't copy it. However, if it's not registered under intellectual property laws, then you are allowed to copy someone else's design, as long as you make it clear that it's not their design, whether it's by the branding. And I'll give you an example. Aldi are huge with this. I purchased some bar stools from Aldi. I love Aldi. Do you all have Aldi? I don't know if you have them in Queensland. Aldi?
Yep.
So I purchased these replica Harry Batoa bar stools, and online, the originals are $300. These were copies. And Aldi is, I guess, brilliant at this because they make it clear that it's not the other person's product by their branding. However, they then, put their own stamp on it and they copy someone else's. And that can include labelling, colours, font in the labelling. So there's all sorts of things the ACCC look at. But you saw in the McDonald's and McWilliams wine case, and this is on page 277, the McDonald's sued McWilliams wine saying, by using the name Big Mac, that you'll mislead consumers into thinking that they're associated with us. And the court said, well, no, it's wine. Really, it's not related to a hamburger. However, often other companies do. So in Parkdale and Puxu, they sold sofas, they were couches, lounge suites, under a range that was very similar to Puxu's brand. And so Puxu actually sued Parkdale, and it went to and fro from court. And the court actually said, and you can see this on page 278, that it was not misleading or deceptive conduct. Can anyone tell me why? So page 278.
They assumed that the consumer would pay attention to the label, look at the brand, and distinguish between the two.
Yeah. So with Parkdale, they actually labelled their furniture, and when you looked closely at it, there were differences. Now, the court sort of said with expensive items, the consumer would look closely and would realise that it wasn't a Puxu sofa, it was a Parkdale sofa.
Michelle, that case prior to that with McWilliams versus McDonald's.
Yeah.
If we lived in a country, and I'm just sort of, I suppose, thinking out loud here, but if we lived in a country that had more liberal liquor laws, and let's say you could buy wine in, well, essentially in the same aisle as you could buy your bread and milk, would that have made a difference, do you reckon, to the outcome of that case? Because they seem to rely on the fact that to sell wine you need a liquor license.
Yeah, well, you need to be a liquor shop. You can't buy it anywhere else.
Yeah.
Yeah. I guess the thing is, a Big Mac is a hamburger. So can you hear me? So my microphone is working.
Yeah, I can hear. You're okay.
Yeah, and so someone can't hear us. So I'm sorry, I can't say if I say it incorrectly, tell me. That Epiphania, sorry, I've got the normal Aussie name, as you know. Can you hear us? You might have to check your microphone. Okay. All right, I'll just write her a message.
It's all right, I've just done it.
Thanks. Yeah, and that's a good point. I guess, because of the so separate industries in Australia, it wasn't misleading or deceptive conduct. And McWilliams weren't doing anything wrong. They were using a play on their own name. And the courts have said that people don't have the rights to specific names unless they're legally registered. So first of all, let's start with the rule. And while I'm typing the rule, I'll explain another case. So with more expensive items like sofas, like outdoor settings, the consumer would be expected to look at it closely. Have a look on page 270, and there in that little table on the bottom are your elements of misleading or deceptive conduct. So under section 18 of the ATL, a person must not in trade or commerce engage in conduct that is misleading or deceptive or likely to mislead or deceive. So that's it, the elements of the rule. So that's what you'd need to start with. Now, if it was an advertising case, you'd need to talk about then advertising and use a case like TPG or Coles or Touri Foods under the advertising heading. If it was a pre-contractual negotiations, you'd need to talk about that. So there's three distinct areas. You wouldn't have time in the exam to talk about all three areas, so you need to identify, which area it would be. So I would then go on to say, as a weapon for business, a competitor can take action against a company if the other company labels a product or makes a product the same as the applicant, that's the person taking the action, which might mislead consumers into thinking they are associated with that company or actually that company. Because with business, especially in a commercial world, that your goodwill, your reputation, your brand is everything. And if someone else is copying or ripping off your brand, then that's a major issue. And so that would be, say, McWilliams Wine's case, McDonald's. So let's apply the elements here, and you could even put Parkdale here. Or you could put a pound and the kettle chip company where they copied the kettle chips. Now, just going back to my point before we apply the elements, when it's an expensive item, the court has distinctly said that the consumer will inspect the items and take note, of any differences or labelling. So, it's harder to sort of mislead if it's quite clear it's not the item of the other person. But with cheap items like cordial or staples like bread, like the Coles case with the advertising, we pay less attention because we're in a hurry, we're running into the supermarket, we're getting our staples, they're cheap items, even like fleeting ads on the TV for internet and things like that. So you don't study the item, you just think, okay, that's what they're saying, this is what I'm getting. So there was a case of Cadbury Schweppes and the ACCC, where the ACCC prosecuted Cadbury Schweppes because their cordial said that it's the label on the cordial had pictures of real fruit, like bananas and mangoes and everything, and it said, made from real fruit. And it turned out there was really no real fruit in there, it was just sort of fruit concentrate, and that was misleading or deceptive, and Cadbury Schweppes was fined really big. So the court said in that situation, when we're purchasing cordial or like bread with the Coles case, we're not going to sit there and study and work out if there is actually real fruit in it. We're just taking it on face value because, of our shopping experience. So it is a bit different when there is more expensive items. But I guess, I'm sort of saying that to give you an overview, but that's probably a little bit beyond what you need to know for this. You just need to know there's 3 distinct areas for Section 18. So let's apply it. So first of all, tell me, is it a person? Is Contour, who is ripping off the outdoor furniture of Trinco, are they considered a person under the Australian Consumer Law? Does anyone know? Well, they're not a person, but just so you know, the Australian Consumer Law, I'm trying to find where it is in the book because I just know it because I know it. A person generally refers to corporations, so and so that means an artificial entity. So that includes natural and artificial entities. So you put under the ACL, a person includes corporations, and when we learn corporations law, you'll realise they are artificial entities, even though not a natural person. So Contour, let's apply it, is a person if they're a corporation, and this is what we're assuming. Hopefully, if it's an exam question, it will be clearer that it's a PTY Ltd, but I'm not going to give you an exam question where they're not a corporation, if you know what I mean. So you would assume straight away they are a person. Now, is the conduct in trade or commerce? That's your next thing. What's the fact say? Is it in trade or commerce? Yep. So it's in trade. So Contour manufacture and sell outdoor furniture. So it says here, meaning of trade or commerce on page 271.
Aren't they? Because they're two companies.
Yeah, well, the conduct must take place.
Yeah, if it was like a company selling to a person, then that would be different.
No, well, it still might be if they trade in outdoor furniture, then it still is in trade or commerce. If I was to sell my outdoor setting at my garage sale this Sunday, clearly that's not in trade or commerce because I'm not in the usual business of selling outdoor furniture. But if that's your business, in the usual course of business, you're making a profit from selling these goods, then that's in trade or commerce. So Facebook sales, garage sales, that's not in trade or commerce, that's private. So is it in trade or commerce? Yes. Contour, manufacturer and sell outdoor furniture. This is their usual course of business. So it is in trade or commerce. There's a lot more to that rule, but you don't need to know it unless you're a law student. It's huge. Now, as long as it's in business, that's fine. Now, the next thing, what is the conduct? So this is where we're applying the facts. What is the conduct? Yeah, well, it's deceptive. So this is where, and, teaching you to apply the facts properly. Yep, so misleading or deceptive. So it doesn't have to be both, it's just misleading or deceptive. So this is where you tell me what they're doing. Contour is selling outdoor furniture. Use the fact that is almost identical to Trinco's. This is the conduct that is in dispute. Okay, so back to the facts. What's the difference between this and the Parkdale case that I was talking about? Yeah, there's a different name. But what about the facts? What do...
Labeling.
The labelling, yeah. So it's not clear on the facts if there's labelling. Unlike Parkdale, it doesn't appear that Contour labelled their furniture clearly. We would need more facts to determine this. It does say that on close inspection, what's it say? Differences are observed. Okay, so I'm letting the marker know that I know it's like Parkdale. and that there is a difference in the facts. So I don't expect you to tell me all the facts of Parkdale, but just that this is a little bit different than the facts in Parkdale. And I think this is, to be honest, one that you could argue either way. You know, again, it's an expensive item. You might say that consumers pay more attention. They'll realise it's different because the facts specifically say if you look closely, there are differences. But then, you know, it's also arguable that it could be misleading if it's not labelled. Does that make sense?
Good.
Good. So I'm going to move on to the next one because the next one's really big. So of course do a conclusion, but we repeat yourself. But you'd need to say if you think it is or not based on what we just did. So let's look at question 7. Lucy goes bushwalking. Well, she intends to go bushwalking in the Grampians. She goes to Kathmandu, and after explaining her situation to Nathan, the shop's manager, the most experienced bushwalker, she buys a pair of Evergrips. The boots are industrial strength steel tip boots. They're unsuitable. They do not grip. They fall apart. After a couple of days of walking, she returns to Melbourne. She takes them back and demands a refund. Nathan says the consumer guarantees do not apply to this store. You're not even a consumer under the law. Advise Lucy of her rights under the ACL. So what area under the ACL are we looking at here? So, you know, there's lots of parts. It's a big chapter. What specifically are we looking at? And there's a hint in there. There's some words that will direct you. Consumer guarantees, very good. Did anyone watch the video that I put in the lecture last week with Julian Morrow and the checkout? Yeah, it was funny. I love it. That was on consumer guarantees, on returns and refunds, right? So realistically, the issue is advise Lucy of her rights, or advise Lucy if she is protected by the consumer guarantees under the ACL. What's the first thing you have to do with the consumer guarantees for them to apply? What's the first thing you need to tell me? So consumer guarantees are on page, far away. It's such a big chapter, isn't it?
Two one, Michelle.
Thank you. 321, right? Consumer guarantees. So what's the first thing you have to tell me? Well, that's definitely one of the consumer guarantees that are breached, and we'll talk about that in a moment. Fitness for disclosed purpose, so that's good, Melissa. But first of all, we need to determine, do the consumer guarantees apply to her? Is she a consumer? Yeah, very good, Kill. So section 3, and that's, you have to make sure you state it. So section 3, I'm going to copy that and put it in. Saves me retyping it. Section 3. So this one will be a little bit of a rule apply, rule apply, rule apply. Do you know what I mean? Because there's sort of different elements to this rule. So first of all, under section 3, you're a consumer if the goods are of a kind ordinarily acquired for personal, domestic, household use or consumption. And I'll change that a bit. Or if the goods do not exceed. So that was not quite right, Keel, and I'll explain that in a moment. So that's or. It's one or the other. So if I buy $50,000 worth of carpet for my house, am I a consumer? Yes, because it's a good of a kind that you acquire for domestic or household use. If I buy a $30,000 software program for my business, am I a consumer? $30,000 software program for my business, am I a consumer? But that doesn't matter if it's for business, if it's below 40,000, Darren. But I guess that's what I'm saying.
You're a consumer.
I'm a consumer, yeah.
Yep.
So
it says it on page 323. It cites it under the farm worker thing.
Yeah, so it says you're either so if I buy a $50,000 domestic swimming pool for my backyard, and it's a domestic home swimming pool, but I actually have people come and have swimming lessons and use it as a business, am I a consumer?
No.
So again, sorry, just the facts I just gave you. It's a domestic size, house size swimming pool. So it's a good of a kind that is ordinarily acquired for personal, domestic, or household use. Okay? So because it's a domestic swimming pool, yes, I am covered, even though it's 50,000. If it was a commercial grade swimming pool for 80,000, no, I'm not covered. So there's a case some years ago, and it's not in this textbook, and I think I mentioned it in the lecture, but it's called Carpet Court and Chan. And Chan purchased $65,000 worth of carpet for his nightclub. And it turned out it wasn't acceptable quality. You know, it didn't last very long. It's obviously in a nightclub. And he tried to sue them under consumer guarantees. And Carpet Court said, you're not a consumer. It's for your nightclub, it's a business, and it's over $40,000. And the court said, no, he is a consumer because it was actually domestic grade carpet. So it was a good of a kind that is ordinarily acquired for personal, domestic, or household use. So does that make sense?
It's going to get super grey now with all the home businesses there are now.
Yeah, but it depends what the good is. If I buy a $30,000 commercial pizza oven, you know, obviously it's covered because it's 40,000, under 40,000. But if it was 42,000, it's a commercial grade pizza oven. I'm not covered. Yeah.
Yeah, okay. I'm just thinking, it just gets really ugly, I reckon now, because like if I think about it from say my point of view, right? Because I'm in the real estate business, so if I was to buy say a commercial grade piece of software, but use it at home, so
yeah, but it's not a good of a kind that's ordinarily acquired, is it?
Yeah, okay.
Yeah.
Probably
But
argue both ways.
Yeah.
Because you could get someone that say is not a professional investor who might own 5 properties that might argue they're a domestic consumer, yet they're making their living from buying and selling properties.
That's okay if it's something that is for a domestic or household use. Doesn't matter if, you know, yeah. And look, I guess that's why we have the ACCC and lawyers in the courts to argue this point, yeah. But I guess the thing is, if you see in a question that it is a good of a kind that is acquired for household use, personal, domestic, even if it's over 40,000, you're still covered, okay?
Okay.
So now you need to look at the consumer guarantees which are breached. So Melissa said one earlier. So Melissa said, and I'll just say it again so that it's clear, fitness for disclosed purpose. Can anyone tell me the section?
It's 55. But also, before you get to that, isn't 54 also in play, acceptable quality?
Yeah, for sure. And that's the thing, there can often be more than one. Now, I'm not going to write you the full rule because this is your job, so I'm going to tell you to expand there. So tell me, what is the meaning of acceptable quality on page 324? You need to expand this rule. What's the meaning of acceptable quality? Safe, durable, free from defects, fit for the purposes those goods are. So always make sure you please cite a case if there's a case in the textbook, even though that's about the blood that he got HIV from. It might not be the same as the facts, but if it's under the heading, it still needs to be cited. Yep, E Red Cross. So acceptable quality. So what happened to the boots? This is where we're applying the facts.
They didn't grip. They didn't. The stitching began to fall apart.
That's right. So please make sure you say exactly, you know, the boots only after a couple of days did not grip, stitching fell apart, not durable, not of acceptable quality, yeah? So make sure you always use the facts for the application. So tell me what acceptable quality is, expand that, and then apply it. So section 55, fitness for disclosed purpose. So do Merck Sharp case. So on the facts, why is this breached? She told them, that's right, what she needed it for. She disclosed what she needed and she relied on their advice. Now, if she had have gone into the store and just chosen a pair of boots off the shelf, then this would not be breached. You have to let them know what you need it for and then rely on their advice. They're the ones that should know their product. So my example was if I have a beach house and I say to someone at the paint store, I need paint that will withstand salty air, and I rely on that, what they're telling me, the paint to buy. I then paint my beach house and the paint starts peeling. Clearly it's not fit for disclosed purpose. So, you know, again, expand that, tell me the rule and apply the facts. She made known to Nathan, and he was the shop's manager and the experienced bushwalker, what she needed him for. She relied on his advice and they turned out not to be fit for her disclosed purpose. Now, just there's another one which probably comes into play here, and I'll just put it as a, I guess it's a catch-all one. Page 326, express warranties, section 59. If they say anything during negotiations, or if there's something labelled on the box expressly that it says it does and it doesn't, then it's also a breach of express warranties. So again, he's saying these are the best boots and they're not. If I went to buy a laptop and they said this is the laptop with the best media card and it turned out it wasn't, that would also be a breach of express warranties. So that's sort of a, you know, generalised one. Now we're going on to the next part of the facts. So Nathan says, he points to something above the front door. What's that called?
Clause.
Exclusion clause, yeah. And what's the section that relates to that for consumer guarantees? Are they allowed to put that sign?
No.
No.
And I don't know the section because I haven't done that this week yet.
All right. So you remember Julian Morrow said they're not allowed to do that last week?
Yeah, but we sort of covered it too a couple of weeks ago with exclusion clauses.
Yeah, but again,
like in contract, and I know this is different, but we sort of covered a bit of it anyway.
Yeah, for sure. But if you get a question in the exam it'll be very clear. Yeah, and that's correct, Darren, section 64. So page 328, have a look, please. Page 328. But if you're in the exam and there's an exclusion clause and it says advise such and such, is the exclusion clause valid, then it's probably a common law thing. Do not answer under the ACL unless it mentions the ACL and tells you about the ACL.
Yep, gotcha. Yep.
And there's exclusion clauses in relation to consumer guarantees under section 64, but there's also exclusion clauses for misleading or deceptive conduct, which is a little bit different again. And I think that's what Nathan's just put, but I'm just finding it. Oh, it hasn't got the section there. Where did you get section 150 from, Nathan? I know it, but I'm just trying to find it. Page 336. That's manufacturer's liability. That's all right, and that's manufacturer's liability. So again, that's a different part of the ACL, okay? So make sure you stay within the consumer guarantees. So section 64 is here that you cannot exclude. It's illegal to exclude the consumer guarantees if it is a good of a kind that is ordinarily acquired for personal, domestic or household use. You cannot exclude or limit liability. So you cannot exclude the consumer guarantees. You cannot exclude or limit liability if the goods are of a kind ordinarily acquired for domestic, personal, household use, right? Now, section 64A is a little bit different. That says that if the goods are not of a kind ordinarily acquired for personal, domestic or household use, then they can't exclude, but they can limit to replacement or repair only, okay? They can limit liability. They can't exclude totally. So for instance, if I purchased a pizza oven for my business, a commercial pizza oven, and it didn't work and I took it back and they said, look, here's our sign. Obviously it's a commercial oven and they can replace or repair. They don't have to refund me. They're allowed to.
Michelle, but if we accept that section 59 is good, so express warranties where she says that this is what I want to use them for and the person in the shop says, great, you need this type, then they can't then plead section 64A, can they?
No, well, she's saying that he said they're industrial work boots, but they're clearly not. You can use them for personal anyway. That's not an issue. I think the thing with that is they are excluding consumer guarantees totally. They're not limiting.
Yep.
See, in the fact, the consumer guarantees do not apply to this store at all.
No,
so,
yeah, he's not limiting. He's saying not at all.
Yeah,
so
that's
64. Right. So 64(1) says that they can't exclude.
That's right. So that's the only one that's really relevant here. I guess I'm pointing out 64A for you guys to show you the full rule. Yeah?
Yep. Okay. Yep.
Okay. Now, the next thing you'll talk about, and again, this is big, I know, is remedies. So if you had a consumer guarantee question, I'd expect you to discuss remedies. And the remedies depend on whether it is a major or minor failure. Now, I don't expect you to determine that. Section 259. Now, in the slides for that week, I actually set this out a lot better than it is in the textbook, okay? So on the bottom of page 329, it says the remedies. And it says down the bottom, where the failure to comply with the consumer guarantee in a contract for the supply of goods is not a major failure, so clearly a minor failure, the consumer may require the supplier to remedy the failure within a reasonable time, or if they refuse to, they reject the goods and recover all reasonable costs incurred in remedying. So that's section 259, 1 and 2, right? Then it says a major failure is defined as the goods have been acquired, rah, rah, rah. So if the failure is a major failure and the failure cannot be remedied, the consumer may choose whether to reject the goods, recover compensation, and in addition recover damages for any foreseeable loss or damage. So again, that's section 259.3 and section 259.4 on page 330. So I would just expect you to say, Lucy can get a remedy depending on whether it's a minor or major failure. She can do this, and tell me what she can do if it's a minor failure, tell me what she can do if it's a major failure. I don't expect you to actually determine if it is a major failure or a minor failure, but you need to address it and tell me the section. Is that okay?
Good with that.
Good with that? Yep. All right, our final question. You all good, Nathan? Yep. Our final question, let's just briefly look at it because we're running out of time, but that's all right. Okay. So Net Pty Ltd provide internet services throughout Australia under standard form contracts that include terms and conditions. And there's a term that states this, advise if this term breaches the ACL, if it does, what is the likely consequence? So what area are we looking at in chapter 13? What's the area? Does anyone know?
Supply of services, but I can't locate the page.
No, so we're out of consumer guarantees now. So consumer guarantees has 3 supply of services. There's only section 61, 62, 63. But again, this is a totally different section.
Oh, okay.
Standard form contracts, very good, Darren. So go to, and I guess, has everyone seen the exam outline I put up? Section 23, good, Melissa. Has everyone seen the exam outline or exam hints document that I put up? Yeah, so it's telling you exactly what topics are examinable. And for instance, consumer law is examinable, but we're not examining consumer guarantees. So realistically, and I'll just give you, an idea here, under certain chapters, there's certain areas that are easy to do questions. So under section 8, under consumer protection, obviously it may be a section 18 question. We've told you it's not consumer guarantees, so don't talk about that if it's in the exam. Or another good question is standard form contracts and unfair contract terms. So go to page 292 for starters, please, and have a look at the heading, Prohibition of Unfair Contract Terms. So page 292. So if you sign a standard form contract, and I'll show you that bit in a moment, and there is an unfair contract term, and it is unfair, under section 23 and 24, the contract term might be struck out as void. So have a look on the top of page 293, the second paragraph. It says, a court can declare a term of a standard form contract to be unfair. Once it's declared to be unfair, it's void, it can be struck out. But the remainder of the contract will continue, if it can continue. If the rest of the contract can't work without that term, then the whole contract is void. Now, the first thing, again, you'd have to tell me here, if it was an unfair contract terms question is, are they a consumer? So again, that heading on page 293, A consumer under Section 23 is one for the supply of goods or services to an individual, personal, domestic or household use. The legislation was changed in November 2016 to now allow to protect small businesses. So that's where the $300,000 or the $1 million comes in. So that's the first thing you'd need to do. Then I want you to flip over to page 296 for me, please. And on the bottom of page 296, it says what the meaning of a standard form contract is. And generally, you know, it's like when you go to Telstra or when you go to a gym, you're handed a document, you're not able to negotiate it, but it says where one of the parties has most of the bargaining power, the contract was prepared by one party before any discussion. So under Section 23, 1B, it says these are the things the court takes into account. So you have to tell me, is it a standard form contract? And this factual scenario is actually telling you, yay, it's a standard form contract. So that's a catchword that you have to look for. Then you would go over to page 294 and have a look at the meaning of unfair under Section 24. And it says, would it cause significant imbalance? Is it reasonably necessary to protect legitimate interests? Would it cause detriment to a party? And it gives you some examples of unfair terms where one party can terminate, one party can vary the terms of the contract, one party can renew the contract. So all of those things are things, and you'd cite some of these cases too, like Crisco Hampers or Ashbourne. And then you'd tell me that if it is unfair, it can be struck out and the rest of the contract is still on foot, if it can still work or not. So is that clear? So I guess what and sorry, I'll wait for your answer. Is it clear? Yeah? Yeah. So I guess what I'm saying is, I know the book's a little bit over the place and, you know, it's a bit overwhelming because it's big, but I guess I'm pointing out these areas for you. And what I suggest you do is you write out a really good rule for unfair contract terms, or you write out a really good rule for misleading or deceptive conduct, and you have them ready to go. Yeah, so follow the flow chart, and that's right. They're the things you have to look at. Are they a consumer? Is it an unfair term? Is it a standard form contract? And it's void if it is, so they can declare the term void. And they're your sections. But just expand a little bit on that. Just obviously don't say, yes, it's unfair. Tell me why. You know, it causes significant imbalance and so on. So I'm just going to stop sharing for a minute, and then I'm going to pull up the practice question quickly because it's the same. And I actually wrote this question because a couple of years ago I joined a gym and he shafted me big time, and I should have known better, but I signed the bloody contract. And can you see this question? So let's just say Michelle joins a gym. And it says the gym fees are $120 a fortnight. UCAM Fitness can change the terms at any time they see fit. And if the customer terminates within a 12-month period, they must pay the $1,000 early termination fee. So he wants to terminate the contract. So these are terms that are clearly unfair. Some might be okay, some might not be, and that's what you'd have to determine. All right. I think that's about it. Does anyone have any questions?
Happy Christmas, Michelle.
Thank you, Simon. Merry Christmas to you, and have a safe festive season.
You too.
I'll see you all in 2019. Can you believe it's 2019?
I know. Yeah, man, I feel old.
Yeah. Thank you, Darren. Merry Christmas to everyone. Melissa, for those who celebrate it. Otherwise, just have a nice break. I'll be working. I'm trying to get your results released before Monday. I'm trying, but we'll see how we go.
Michelle, happy to accept email over the break if there's anything. Is that okay?
Yes, for sure. If I don't answer straight away, I might not be in service.
No, that's fine. I mean, it doesn't have to be.
Honestly, feel free to contact me over the break. Just give me a little bit of time to answer, but I'm happy to talk to you all. And otherwise, I'll see you on the 9th of January. Well, talk to you.
Thanks, Michelle.
No worries. Take care.
See ya.
Yeah, there was a lecture, Nathan. Was it recorded? Because there was some major cloud issues. Oh, it hasn't gone up yet. The live lecture, I couldn't connect to the internet, and I had to connect to my laptop. So we might have to wait and see. Hopefully they've resolved it and they put it up this afternoon in the morning. But yeah, apparently the people that attended the live lecture, they were cut off and the whole system went down. Yeah. So we'll keep an eye out because I really don't want to record it again. All right. Very good. Thank you, everyone. See you later. Bye.
Hi, Michelle. It's Nathan. Are you still there for a second?
Yeah.
Sorry, I just had a question because I emailed Ali early in the week as well as my accounting lecturers. I handed up my law assignment 1 to accounting.
Yeah, I saw it.
Oh, you have? So it's going to get marked?
Ali and I have been emailing back and forth about it and to your other lecturer.
Yeah.
And I've noticed we've just had another email from the Director of Teaching and Learning in Law. So I'm just waiting on Ali's feedback as to what we can do. I'm hoping it'll be positive, but I'm just waiting. So we are definitely dealing with it. I'm just trying to work out the best way because unfortunately we have to talk to other powers that be, if you know what I mean.
Yeah. No, that's cool. I just hadn't got any response from Ali, so I didn't know.
Okay.